today we've got Greg Beyer, who is Greg. How would you describe yourself? Attorney?
I'm an attorney. I do business structuring as well as other things to help people to be able to protect their assets from creditors as well as get maximum tax benefits from the way they do things.
And we want to talk to you all about that kind of stuff and relating around real estate. Like, how does
Okay.
that stuff affect? So, what's the first stuff that comes to your mind when you're thinking estate planning and real estate? Because I
Well,
know you've been through a lot more clients and that aspect than we ever have.
yeah, well, I've actually done estate planning, what you just mentioned. I've had probably about 6,500 trust clients, but a business structuring is what we do most on here. I got about 2,700 people that we've done specific business structuring for that has most of it has to do with real estate. And so we've got all kinds of fun things that we've done to be able to help people to do it so that it's not a burden anymore. It's not something that you sit there and say, oh no, I got that stupid rental over there I got to take care of. We're going to make it so it's not stupid anymore. We're going to help you to appreciate the rental.
Now, I know from my years of working with investors, a lot of them are concerned about asset protection, especially here in California, with
Yes.
regard to, and that's why they do different entities. So I know you've advised a lot of the clients. What do you, and Mike and I, we have properties in other parts of the United States, and I typically hold my properties. I either hold them in my own name or I hold them in an LLC, depending on depending on what we're trying to do.
Okay.
But tell us your thoughts on that.
So let me give you the idea. So when we're doing asset protection planning, you have to
Mhm.
realize the basic rule is if your name is on an asset, your creditors get it. And so people think, okay, I'll go ahead and fix that problem. I'm going to go ahead and do a trust, a living trust. I'm going to put my name on the trust name on my asset, and now they can't get it. Well, there's an exception to the rule. And the rule is unless it's in a trust. Okay. So the deal is that yeah, you can take your name off and put the name of your home in the name of the trust, or put your bank account in the name of the trust, or the investment account in the name of the trust. But if you are sued, whoever sues you and gets that judgment, they're able to take your trust assets, every piece of it out, and be able to do it. I'll give you an example. So let you walk across the street and you run over the neighbor's dog, and I'm not going to talk about whether you did it on purpose or not, okay? Even though it's barking all night. And so the deal is you run over this dog, and the neighbor is irate. He says this is the best dog in the world. It's $1 million dog. And so I'm going to go ahead and sue you. And the judge looks at, lets you go through court, and you find out. And he says, I think it's $1 million dog. And you did it. You shouldn't have run over it. So I'm going to give this creditor, this judgment creditor, a judgment that says you owe him $1 million. So what's he going to do from there? So that's the first half of a lawsuit. The first half is showing liability and showing damages. And so the liabilities, you did have your responsibility to drive safely, okay? And you did kill the dog, okay? And so we have those two things settled. The second half of a lawsuit is going to be, how do I collect the money the judge says you owe me? Okay, this is where we work. This is the area we work in. We can't stop people from suing you. People are suing people with or without cause all the time. We can't stop them from winning. Okay, we try, but the deal is some of the time you really did the job that you caused the liability. And so now what we can do is we can actually stop them from taking your assets. So right now, you've got this living trust, you got your house in there, you got a rental in there, you got your car, your gold and silver, your all the things that you have. And after they get this judgment, they get to have a hearing called an order of examination. And the order of examination is where they get to come and have their attorney find out what you own. So there's this little gal sitting at the end of the bench, and she has hold your hand up and you say, I promise to tell the whole truth and nothing but the truth, so help me God. Except you don't have to say for help me God in California anymore because he doesn't matter, I guess, here. But the deal is, and then you got to tell the truth. And they get to say, do you own a house? And if it's in your trust, you have to say yes. Do you own a rental? Yes. Do you have gold and silver? Yes. And I've got a car and I've got a dog and I got socks and shoes and a bank account with $13.50 in it. And so now that they know what you have, they get to pick and choose the things they want that they found out from you and go and take those to pay off this $1 million judgment. And you end up walking out of the room and you think, I just shot myself in the foot because, I just told them all the stuff that I have. And who knows, you may end up having to go and live under a bridge. And I'm sure you can find a nice bridge somewhere. But the deal is, you don't have anything anymore. And you sit there and think, this is no good. So what we do is we use that basic rule. If it's not in your name, they can't get it. We create another entity. And the entity that we create in California is a family limited partnership. The entity we create in every other state, because we work in all the states of the United States, we use an LLC, limited liability company. We believe that the California LLC laws are defective. They do not protect you. You have to pay tax when you don't even have an income sometimes. They are not allowed to be used by most of the type of businesses that we have in California, including doctors, lawyers, accountants, CPAs, realtors, dry cleaners, auto mechanics, construction companies. They can't be used by any of those, but people use them anyway. And so when they go out and use them, then because they're using them when they're not authorized to use them in California, they give you no asset protection there. So we use an FLP, so we don't have that issue anymore. So now what we do is you put your house, we put your rental, we put your investment account and your stocks and your gold and silver. We don't put your car because nobody wants that anyway. And then when you have that hearing, that order of examination, when they ask you, do you own a house? You get to honestly say no, because you don't own it anymore. The limited partnership owns it. Do you own a rental? No. Do you have any gold and silver? No. I say, what do you have? Well, I've got a dog. I got my socks and my shoes. I got this account with $13.50 in it, and I have a limited partnership interest. So what happens is that it makes it so that the creditor is going to go back to the judge and say, Judge, I've got a problem. I went and looked at the stuff that was in the trust. It's a bunch of junk. I don't want any of that stuff. But they had this one thing that might be of value, and that is the limited partnership interest. Can you go ahead and give me that limited partnership interest? This is the creditor talking to the judge. And the judge says, you know what? If it was a corporation, I could give you the corporate stock and you could go ahead and take whatever's in there. If it was a general partnership, I could give you the general partnership interest. If it was a California LLC, will probably give you the LLC interest, but I can't give you the FLP interest. The FLP has a special rule that says you can't take in limited partners' interest. You only have one remedy. Now, remedy means what you can do to go get it. And that one remedy is called a charging order. And the charging order basically says that if the limited partnership pays out profits at the end of the year, then that creditor gets to take the profits. And so the creditor will say, well, that sounds better than nothing. And so they come and say, well, I'll go ahead and get that charging order. So they get the charging order and they're waiting to the end of the year to see how many profits there's going to be. And let's say in an example, we have $100,000 of profits in this business. Had a great year. Things went well. And so this creditor's getting really excited because he's going to be able to go ahead and take these profits. Well, because of partnership, remember partnership means two people, okay? So we have the client whose trust owns the 99% of the FLP, and we have another entity called that is a Wyoming LLC. Okay. This Wyoming LLC will be the general partner of the partnership. So the trust is the limited partner. The LLC is the general partner. And who owns this Wyoming LLC? My clients do. Okay. Husband and wife. And so they're going to go ahead and they're going to own this. But in Wyoming, they have a rule that says that you can't sue the owners of a business in Wyoming. And so that's why we go there to create this entity. Now what happens is this creditor who's sitting there waiting for the money. This LLC in Wyoming makes the decision. Of course, the LLC in Wyoming is controlled by my clients. They just make the decision. We're not going to make any profit distributions. We're just going to keep it all. We're going to go on a cruise to Mexico, or we're going to go and buy a piece of property and get some gold and buy a new dog, whatever it is that we're going to do. We're not going to make any distribution of profits, just keeping the money. So at the end of the year, instead of giving the creditor this check, the creditor instead gets a tax document called a K1. K1 is just a document that says somebody needs to pay tax on the $100,000. Now, since the creditor took on the opportunity to receive the um, the profits, they also took on the responsibility to pay tax on those profits. So we're going to go ahead and keep the profits, the $100,000, but the K1 goes to our creditor. So they end up paying tax on the $100,000 that we never gave them. And we just hope that they're going to be there next year. Nutshell, that's kind of what we do for people. And there's lots of other things that we can do, but that's in a nutshell what we try to do.
So then
So you
you go back to the attorneys that had sued you, and or the attorneys for the individuals that sued you, and say, shall we do this again next year and the year after, or shall we settle at something that we
You
can all
bet. I'd
agree on?
even go and say, I'll tell you what, I'll give you 5,000 bucks if you keep the charging order on there, because I'd love you to pay my $40,000 in taxes again next year.
so they actually have to pay that 40, let's say it's 40 grand. They would actually have to pay out of their pocket the 40.
That is correct.
And if they don't,
If they
then
don't, then the IRS is
it's
going to come to
IRS.
them and they're going to go ahead and be in trouble, like if they didn't pay their own personal taxes.
I'll be danged.
Isn't that wonderful?
It is.
So the
Wow.
interesting thing is, because this entity is in Wyoming and we have that special rule that says you don't get to sue the owners of the business, Wyoming is also a long way away. So your creditors, attorneys can't go into the courts of Wyoming. You have to hire somebody to do it.
Hmm.
And Wyoming has no business taxes. And Wyoming likes businesses more than they like people, which is why there's only 13 people that live in Wyoming. And so the deal is that if there's going to be a lawsuit, most of the time the business wins. And so we're okay. So they may come and say, hey, you made the decision not to make that distribution. And so we're going to come after you, Wyoming LLC. And they come after it. And if they actually did all that stuff, the entity has maybe $1,000 in the bank or something, and that's what they will get. And they can get that, but they can't touch a single thing in the limited partnership.
Yeah, because
Wow.
the entity is only a 1% owner, or whatever percent owner of the
But because the
everything
entity is
else.
1% owner, they can get a judgment against that entity, but can't get it against the limited partnership.
Right.
So, yep.
But they're a minority owner. They have a
Yes.
minority interest, so they have very little capital to
Yeah, and we
pay.
already
The
have within the FLP document, we've made the election to have all profits and losses go to the limited partners and none of it going to the general partner. And so the
So the
deal is
general
the
partner
general
could,
partner has nothing to share.
so technically the general partner could have $1,000. They can come and seize that
Mhm.
and pay 40,000. So,
That's correct.
yeah,
so they
That
so they only
happens.
owe 39,000.
Yeah, and we've been doing this for
Wow.
a long time. We've been doing this type of planning for 35 years. And we not once have I ever had anybody get through any of the limited partnerships that we put together. And to be really honest with you, because other attorneys know these benefits of the Wyoming LLC, I've never even had somebody come against one of our Wyoming LLCs.
So
Really?
you've never had a situation where they had to pay the tax on the K1s.
Yeah, they have to pay the tax. I've
Yeah,
had
but
some people get the charging order, but they've never
oh,
gone against the
oh, okay,
LLC. Yeah,
okay,
Right.
wow. So you
So,
headed off early.
that's what it is.
yeah, a lot of the people that you've seen, what's the biggest mistake that you've seen and that people have made when they come in to see you or before they come in to see you?
Oh, what a lot of times they sit there and they think they start a different kind of a company. Okay. They'll do a
Okay.
California LLC or they'll do a corporation or they'll do something like this thinking that that's going to protect them. And I help them to understand when we work with business entities, every entity has their own purpose. That they do different things. So people, when they come to me and say, I want to start a corporation, and I always ask them, why do you want to start a corporation? And they say, for the protection. And I say, well, what is it going to protect? Well, it's going to protect my assets. Well, let's talk about this for a second. Corporations don't protect assets. Okay. If you
Mhm.
get sued and or the corporation gets sued, they get the corporate stock, they can take all the assets that are in there. So that's not going to protect assets. So what protection does it give us? It gives us protection from other people's acts. So if my secretary goes out and runs over the little old lady going across the street at lunchtime, and that little old lady sues and gets a judgment for $10 million, she can go after my secretary because she ran her over. She can go after my corporation, which it hired her, and she will try to go after other people, but the fact is those are the only true defendants. Now, I had an experience one time that somebody had hired somebody, caused some liability, and the judgment, not the judgment, but the lawsuit went against the person that sued, which was one of the employees, the corporation that hired the employee. They sued my client, who was the president of that corporation. They sued my client as the director. They sued my client as the officer. They sued my client's wife. They sued my client's limited partnership. They sued my client's trust. They probably would have sued the dog if they had the dog's name. So the deal is, what do we know about this attorney? Great attorney. Okay. He's doing just what he should do. You want as many pockets as possible in case some of them fall aside. We have more pockets to get judgments from. Now, the problem is my client, because you were saying, what's the biggest problem? He went and it turned into a lawsuit to his insurance company. His insurance company hired an attorney, and the attorney answered on behalf of him and all of those defendants. And the answer was what we learned the first day in law school. Not my fault. The other guy did it. Okay. That's basically what his response was. And so the problem was, he comes to me and says, I'm involved in this thing. I did the corporation, I did the limited partnership, and yet I'm still involved in this lawsuit. How is this going on? And I said, well, your attorney was supposed to do a thing called a demur. It's a really weird word that comes from Latin that just says you're suing the wrong guy. And he was supposed to, instead of answering on behalf of your wife and your trust and your dog and all this, he's supposed to do this demur, and it will kick them out of the lawsuit, including yourself. So I called his attorney while he was in my office. I explained to him that he should be doing this demur, and he said, and this was his answer. He said, "Oh, I remember hearing about that in law school." That was his answer. This is a litigation attorney. And so I taught him how to do a demur. He did it, okay, and he sent it to the judge. Now, it was already too late. You know, you're supposed to do it before you answer, but he did it, and the judge was kind and wise enough to accept it on everybody's behalf except for the employee, the corporation, and unfortunately, my client as the owner of the corporation, which he shouldn't have been there, but he didn't let him go. And we settled it, and everything went fine. But what's supposed to happen every time you do a business entity? The entity is a defense. It's like a shield. And if somebody's shooting arrows at you, you can have your shield at your side, and those arrows are going to still hit you and kill you, even though you've got this defense. When you have a corporation or an LLP or an LLC, the deal is you have to lift the shield up so that it hits that. You've got to bring up the defense. So he hadn't brought it up. So when you ask what's the biggest thing, they try to do things without understanding what's going on, or they use the wrong entity. They come in and says, I put my house in my truck and my corporation, so now we're protected. And I say, well, guess what? You're not protected. It's not going to help you. And so we have to do the right thing. We have to use the right entity for the right purpose.
Right. Okay. I have a two-part question. One is why no LLCs in California? Why do you do FLPs instead of LLCs? And you already explained a little bit of that with regard, but specifically with regard to real estate. And then the second thing is I've heard over the years, and I'm pretty sure it's attorneys who are just trying to generate income off of creating LLCs. And so they'll say, well, you have 5 properties, you need 5 LLCs, one to protect each one. And I, and, I just, I, I'm not of that belief. So I would love to hear your thoughts on that as kind of the second part of that.
Okay, so once again, we kind of talked about why we don't use LLCs in California. They don't protect you. You pay tax when there's no, you can pay tax when there's no profit, and most businesses, if you are registered with anybody in the state of California, you're not supposed to use an LLC.
Right.
And so,
But if you're just a grandma and you
if
have
you're
your own
selling
house and you have a
cupcakes on the side of the
property,
road, you can use an LLC. That's
yeah,
fine. It's going to
okay,
work fine. Okay, except because most LLCs are used by inappropriate companies, the courts are still allowing people to even get into those type of LLCs. Okay, but let's talk about this other one, these multiple LLCs. In the perfect world, you would have everything you own, you'd put in a separate entity so that it separates it from everybody else. Back in the 80s, they used to do FLP chains, we called them, okay? And they put the house in one thing and the furniture in another thing and the cars in another one. And you just have all these things. And it did separate it. There, by the way, that was found at the way they were using it as an illegal thing, and everybody who did that back in the 80s got in a lot of trouble. There were a lot of people that did that in the 80s got in a lot of trouble. But the deal is, we like having things separated. It's like putting a bad apple in a good bushel of apples. It's going to cause problems with the other apples. So if you were to buy a 8-unit apartment complex. And the deal is what I've heard, and that I've always believed this, and I believe that I've seen this to be true. If you have 8 units or more, you have a better chance of getting sued every year because you have a lot more things that go wrong with those type of things. Okay. So the deal is if you had an 8-unit apartment complex and you had a single family home, if you put those in 2 separate entities, okay, and then they're going to be protected from each other. So if somebody sues on the one, they're not going to be able to affect the other. Now, you can use that if you wanted to. You can put one in a California LLC and then put it in the FLP. Now you have the protection, right? And then you can put the house in the FLP too. So they're separated because one is in an entity within the FLP while the other one is just owned by the FLP. So having things separate is good. The problem is you have the expense of that. In some states, it's not a big deal. Wyoming, it's like about $295 to be able to take care of all the expenses you need for a Wyoming entity. But California, there's a fee, a tax, franchise tax that's $800. Plus, you have to do a tax return for each one. And so, if you had 5 properties and had 5 FLPs with 5 $800 fees and 5 tax returns, that gets to be pretty pricey. Okay. Now, if you have 100 properties, maybe it's better to go ahead and make more. I've got my own personal opinion is if you have 5 or less properties, you can put them into one entity, okay? But once you get to 6, it's time to do a second entity, start that second apple basket, okay? So that we can
Okay.
kind of keep some of them apart. If you have an 8-unit apartment, you want to put that in an entity so it separates it. So we would do that in its own entity, and it can be held in your FLP after that. But you have to kind of keep it separate because of the lawsuits.
Okay, quick question on
Good.
digging down into those 5 properties. If you have 5 properties and each one's worth $100,000, or 5 properties and each one's worth $500,000, would you make any changes? Or would you still do it? One's at 2.5 million, the other one's at 500,000 gross
So in that
asset
case, I
value.
might have 2 FLPs. Okay, if
Okay,
it's a higher value like that.
right.
And sometimes we do it when it's not even real property. Sometimes people just say, "Hey, I got this $3 million over here," and so I said, "Well, that's nice that you've got it in your bank account, in your trust, so anybody can come and take it if they want to. You're such a kind person. But if you want to protect that, you need to put it into an entity to protect it." But yes, the values would make a difference. Okay. And the amount of people in the building would make a difference. So
Okay.
that's the things that I
So
would look at.
yeah, so your thinking is up to about 5 properties, single family, and if it's 8 or more, make it its own.
Yeah, then we're gonna go do different. And the thing is, if you have properties in another state,
Mm,
okay. Now, if you only have 2 properties, one in Utah and one here, then you're probably just going to use one entity, okay? But
right.
if you have, 2 properties in Florida and one in Ohio and one in Utah and one in Nevada and 4 in California, I put the 4 in California in one entity and I'd put the other ones in an out-of-state entity. Why
Yeah.
even get them involved with California? If you put your Utah property in with your 4 California properties, guess what? California's tainting all those things that are not even here. So I just
Yeah.
keep those separate from each other.
That makes total sense. I feel the same way. It's like
Well, you're a
California's got enough litigious people that just
there are, and right now,
separate them.
what they're saying is that 1 out of 4 people get sued per year in California. That's how many lawsuits are being filed in California. So you have a 25% chance of getting sued. Now, I have to admit, over 50% of those lawsuits have to do with car accidents.
Mm.
So that's
Mm,
why we don't put cars into our FLPs because it's bringing that liability in with all of our good stuff, right? So that it's like getting a safety deposit box and you put your pearls in there and you put your jewels in there, you put your deed in there and all these things. And then you go ahead and put your stick of dynamite in there also. Okay. It just doesn't make any sense. Put the stick of dynamite somewhere else. I actually had one client we did structure for, and he had some properties and things, and he had a business that was, well, it was actually a recycling place, and he had this great big machine that's bigger than my office here that they just throw the things in and it just shreds it all up. It doesn't matter if it's a chair or a table or paper or what, it just shreds it up. And all you have to, I mean, it was open and you could just see how somebody could just fall into there by
Mm.
accident and they're just going to be little pieces on the other side. So we put all of his dangerous stuff into one FLP, put all of his non-dangerous stuff in another LP, and we named the non-dangerous stuffs, ND, FLP, which is non-dangerous, and the other one is DA, dangerous asset FLP, and we just kept them separate from each other to make sure that they didn't cause an issue back and forth.
So what's
That's
another thing that people have problems with relating to real estate and estate planning?
Well, the deal is a lot of people they're traditionally trained that their house has to be their house. Okay. So I'll give you an example. So when I have a personal residence and I don't now, but I had a personal residence and the personal residence is only able to deduct certain things as taxes. Now realize using an FLP, that means your assets are owned by a business.
Mhm.
Now, the difference between business assets and personal assets are that the business assets you get to have they have business tax deductions on, business expenses. Personal, you don't have that. And so the deal is that by putting my house, well, keeping my house out, if I paint it, that's not tax deductible. If I put a new roof on, it's not tax deductible. If I fix the plumbing, it's not tax deductible. In fact, there's very little that you can deduct as a tax deduction as a personal residence. So by putting the house into the FLP, it becomes a business asset. So now we treat it as a business asset. So we're going to pay rent on it, just like any other rental that we would have. But because we pay rent on it and it becomes a rental, we can now legally write off things having to do such as we can write off the taxes, we can write off the insurance, we can write off repairs, we can write off the new paint job, we can write off the new patio we put in, the flowers you buy at Home Depot, we can write that off. We can write off the hose that we need to water the flowers with. And we can write off the shovel we buy to plant the flowers. We can just all of a sudden, a lot of things that we have to do become a tax deductible expense instead of a personal expense. And so we're actually able to go ahead and take a lot of deductions. So what it is that people, they'll sit there and will put the house into the FLP, and then they keep telling their CPA, this is my personal residence. Well, it's not a personal residence anymore. Personal residences don't get tax deductions. Okay. But if you say this is my rental that I'm living in, now you can do it. And now you treat it like a rental and you do everything you do like any other rental. And then you can actually legally take deductions on this. I have
So
Right.
then,
over
so,
100 or more CPAs that are doing this for these 2,700 clients I've got that are doing this, and they have no problems. We've never been audited once. And
so
because the law allows it. Yes, go ahead.
so when you get ready to sell the property out the other end, you don't get owner occupied treatment of the 250 or 500,000
You
couple, right?
wouldn't unless you take it out of the FLP before you sell it. Now you've lived in it 2 out of 5 years. Remember the rule for that
Right.
is you live it 2 out of 5 years, and it has to be a personal residence.
So
So
you have to
right at the
wait two
moment, if it's
years.
in the FLP, it's not a personal residence, but you've lived in it 2 out of 5 years. Take it out, it becomes a personal residence again, and you get to get that $500,000. We've done it dozens of times.
So you have to wait the 2 years or just take it
Nope,
out and
you've already
you're
lived in it
good.
2 out of 5 years.
Ah, okay.
Okay, that's what I thought at first too. You'd have to wait for an additional 2 out of 5 years. But it doesn't say it has to be a personal residence that you've lived in it for 2.5, 5 years.
Right,
We say if you've lived in it 2 out of 5 years and it's a personal residence. So we
right.
get that. And we make sure that our clients understand that. There's one time a client just sold his residence without taking it out. And so that,
Mm.
of course, he was going to owe about $60,000 in taxes. And he comes to me and says, what's going on here? And he says, well, you're supposed to take it out first. Remember, we talked about this. And he says, oh, yeah, you did talk about it. I forgot. So what we did is he and his CPA and myself, his CPA did a lot of work on this. We went and we talked to the franchise tax board. We talked to the IRS and we showed them that he'd been living it for the amount of time and all this, and we were able to convince them that it was a personal residence, and they gave him the credit. Okay,
So
but it was a
was he
lot.
able
You don't want to do
was
that. You have to.
was he able to take depreciation over that period of time along with the expenses?
Yes,
So he was able to depreciate over the 27 and
just
a
like a
half,
normal
just
rental.
like normal rental.
Yeah.
I'll be danged.
Mm, good
Huh.
stuff, Greg.
So these are the
I need
kind
to
of
come
things
by
that
and talk to you.
and I work, tell you the truth, I work with people all over the United States. I have clients in every single state of the United States. And so the deal is we're able to go ahead and if they come and say, oh, I've got a house in Florida, well, we're not going to open an FLP. We're going to open an LLC in Florida. And then we'll still have an entity, a Wyoming LLC being the managing partner of that LLC. Because remember, what causes liability is making decisions.
Hmm.
If you make a decision, you're liable for any damages for that decision. That's why the general partner can't be you. It used to be that you could be your own general partner. And then the courts started allowing creditors to go after the general partners, which were the owners of the FLP. So that's when we started using LLCs in Wyoming. And since then, haven't had a single issue with any of our general partners. Because
Hmm.
we do it all legally. We're just following the things that they've given us the ability to do. You
So
have
would
to
you have a
read.
general partner even on an LLC?
What's that?
You'd have a general partner even on the LLC, or is it just a
You'd have a
managing partner?
managing partner.
Man,
It's not called a general partner
yeah,
on an LLC.
managing member or
We have a managing member. That's what it is. And
okay.
so the deal is that if you had four entities, we just have to have one managing member that can be the general partner or the managing member of all these entities. You don't have to have one for everyone. Just
And,
one takes care of that.
and can I be the managing member of the managing member
Yes,
LLC within my own LLC?
you certainly can. You will control the Wyoming LLC.
Right.
Okay, or you and your wife, okay? Sometimes your wife, and you can do it if she lets you, okay? So that so the deal is you get to control whatever. That's why you get to say no distributions this year. We're going to go ahead and buy a new piece of property. We're going to go ahead, we can do all that thing. The LLC is going to make those decisions. You make the decisions for the LLC.
Right.
General
Right.
partner, I mean, as the general partner, you now get to, the FLP gets to live with that. So we custom make these things depending on where you're at, what you've got, what you're trying to accomplish.
So Greg, what else would you want people to know?
Okay, they need to know this because we now have a business, we get to write more things off as tax deductible. Okay.
Mm,
And with the reason we get to, if I wanted to go visit my sister in Georgia, if I were to go ahead and when I go to Georgia to visit my sister, I spend a few hours looking at real property there, okay, for to add to my rental stock. That made it a business trip. So all of a sudden, the expenses for that trip are tax deductible. It can be paid for by your FLP. And so, because you have a business, the thing you'd want to know is since you have a business, you're able to write more things off because you can write them off as business expenses, which you can't write them off as personal expenses. We tell people, we show people all the types of things they can do, and some people say, "Oh, I don't want to do that," so don't do it. Or they
yeah.
say, "Oh, I'm going to do that." But the thing that we teach in the end is just be honest about it. Okay. The fact is, if you're going to go on a trip to see your sister in Georgia and you don't actually go see any, any realtors while you're there, then don't write it off as a business trip. First of
Hmm.
all, we don't want to be dishonest. We want to feel good about ourselves, and we don't want IRS looking over our shoulder, wondering what's happening. All you got to do is lie once, and they think that you're going to lie all the time. So the fact is, be honest with whatever you're doing. And if there's something that we mentioned, say, hey, this could be a business expense, and you say, oh, I'm not comfortable with that, then don't do it. We're just showing you all the different options. That's all we're doing. And
Yeah.
that's what I say. It's a custom thing that we do for each client. We do a lot of training. You have to be trained on how to do this. Otherwise, you go away and you got some binders and you haven't a clue what to do with them. We don't let you do that. We train you how to do this. That's what we do.
Mike, do you have any other questions?
So, Greg, you own some real estate. So,
Yes.
do you recommend investors owning real estate as part of their portfolio?
Oh, definitely. I think real estate is the most substantial thing that you can have. I mean, I had a crypto account and I lost money on it. Okay.
Hmm.
Although
Hmm.
right now, if I'd still had it, I'd have made money, right? But the deal is you never know. I've had investment accounts, stocks and bonds go up and down. The real property is always there. And if you're
Hmm.
using it as rentals, even if the property value goes down, the rents don't usually go down.
Correct.
You're still
Yeah.
renting for the same thing. And so I don't really even care if the properties all go down by 25% because my rents don't go down by 25%.
Well, not only that, you get the deductions on the expenses, which offsets your income and your salaries. So, yeah, you get to keep more tax money in your pocket.
That's what you do.
Yep.
So yes, I've had real property in my portfolio as the major part of my portfolio for probably 40 years.
Mm-hmm.
40 years. And
Mm-hmm.
sometimes it works out as good as I hoped it would, and sometimes it doesn't work out quite as good. Sometimes it's better. And so you
Yeah.
never know what's going to happen, but just hang on to it while you can and just rent it. And that brings you income. Right now, if something happened to me, I don't have to worry because all of my rentals are paid off. I got four commercial buildings, and they're all paid off. And so the deal is my wife would be able to live comfortably on the rents that she would be getting from the thing, even though I'm not here earning anything,
Mm-hmm.
attorney anymore.
Mm-hmm.
Yeah.
Well, that makes great sense. So, okay. Well, do you have
Okay.
any other questions, Joel?
No, not
I mean, that
today.
was, yeah, that was extremely informational. Um,
Greg, thank you so
always
much
learn
for your
something
time
for
today.
you, Greg. Yes, sir. Thanks, Greg. We appreciate it.
Been a
And
pleasure. And if you have other questions, you just let me know.
we will. We will. I'll be
We will.
talking to you.
Thanks for your time.
Okay, thank
Thanks,
you.
Greg.
All
Bye
right.
bye.
Bye
Bye
bye.
bye.